The Gyanvapi dispute has again hit the headlines, with the Supreme Court asking the A side to defer a proposed excavation inside the mosque complex till July 26th. This would allow the Mosque Managing Committee to go to the Allahabad High Court against a district court order which had directed a survey and excavation to establish the mosque's origins. The Uttar Pradesh government resisted a stay on the district judge's order. The Uttar Pradesh government, through Solicitor General Tushar Mehta, claimed that the survey would be non-intrusive and would not pose a threat to the structure. It would only involve photography and radar imaging, Mehta claimed. The Supreme Court, though, imposed a status quo till July 26th. Early morning today, a whole team of ASI officials, around 30 to 40, had landed up at the mosque complex even before the hearing of the case began. After the Supreme Court imposed the status quo, things went back to normal. But what exactly is the dispute all about? The dispute is very similar to the Ayodhya dispute. At Kashi, the Kashi Vishwanath temple sits next to the Gyanvapi mosque. There have been minor skirmishes between the two sides, but the case only reached the courts in 1991 when the local priests moved the courts to take back the entire complex. They demanded that the Muslims be evicted from the spot and the entire complex be handed over to the Hindus. This case has since lingered on, and the first round of litigation was stayed by the Allahabad High Court for well over 2 decades. But it was only the resolution of the Ayodhya dispute in 2019 which gave a fresh impetus to the Kashi and the Mathura cases. In both these cases, fresh petitions were filed to reopen the issue. In the Kashi Vishwanath case, petitions have been filed to establish the origins of the mosque, as also to press for the Hindus' right to worship inside the complex. The Mosque Managing Committee claims that under the Places of Worship Act 1991, status quo would have to be maintained at any place of worship. If a temple is a temple as of August 15, 1947, it would continue to be a temple, and a mosque would continue to be a mosque, it says. And hence these issues cannot be re-agitated in the courts. But CJI D.Y. Chandrachud opened a virtual Pandora's box when he said that the law does not bar an examination into the nature of the place of worship. This left the door open for not only Mathura and Kashi, but for fresh petitions to be filed all over the country regarding any place of worship. The Mosque Managing Committee claims that these orders have also resulted in 2 orders being passed asking that the entire area be surveyed and excavated to establish the claims of the Hindu side that there was a pre-existing temple at the site. The Mosque Committee says that the initial survey was restricted to the Wuzu Khana, where the Hindus claim there is a Shivling and the Muslims claim it's just a fountain. That was stayed by the Supreme Court. After the Supreme Court stayed that survey, the Mosque Managing Committee says, how can another court order a survey of the entire complex? That is the issue that will now be agitated before the Allahabad High Court. Thanks for watching.